Even if you've had your green card for years, a potential shift in government enforcement policies expected around February 2026 could put you at risk of deportation for simple mistakes. In this video, I'm going to reveal 5 little-known triggers that could jeopardize your American dream and show you exactly how to protect yourself before it's too late. My name is Leonardo, and I'm the founding attorney of the American Dream Legal Center. For over 15 years, I've dedicated my career to one thing: defending the rights of immigrants and helping thousands of families secure their future in the United States. Today, I need to talk to you with a sense of urgency. The immigration landscape is shifting. With predictions of intensified enforcement, the level of scrutiny on lawful permanent residents could reach a point we have not seen before. This isn't just about targeting undocumented immigrants, it's about a systematic, data-driven review that could impact every green card holder in the United States. What does this mean for you? It means things you thought were safe, small mistakes you may have forgotten, or simple choices you make every day could now be compiled and used against you. The very definition of permanent resident feels less permanent than ever. Lawful permanent residents can lose their status under certain circumstances, such as criminal convictions or immigration violations. Over the next few minutes, we're going to dissect 5 of these deportation triggers. These are not just the obvious headline-grabbing crimes. These are the quiet, insidious risks that are catching good people completely off guard. We'll talk about how old criminal records are coming back to life. We will discuss how your travel patterns can be misinterpreted as abandoning your U.S. residency. We'll uncover how the public charge rule is being used to create obstacles for established residents. We'll look at how simple administrative mistakes are being bundled together to create a negative profile. And finally, we will explore how the government is using powerful technology to uncover any misrepresentation on applications from decades ago. For each of these 5 triggers, I won't only explain the problem in plain, simple language, but I'll give you a real-world scenario of how it's happening. Most importantly, I'll give you a clear, actionable checklist of what you need to do, starting today, to protect yourself and your family. Your American dream isn't a final destination. It's a status that, now more than ever, must be actively maintained and defended. So please, pay close attention. The information in this video is your first line of defense. Criminal convictions, the digital ghost in your past. The first and perhaps most alarming trigger we're anticipating with intensified enforcement is the government's new ability to resurrect the ghosts of your past. We've always known that certain serious crimes can make a green card holder deportable. But the game is changing. What was once a forgotten mistake, a minor indiscretion from 10, 20, or even 30 years ago, is now a potential ticking time bomb. Here's the problem. Federal immigration databases are now integrated with state and local law enforcement records more seamlessly than ever before. This enhanced data sharing means that an old arrest, a dismissed charge, or a minor misdemeanor conviction you thought was long gone can now be flagged and delivered to an immigration enforcement officer. Even records that have been expunged can still be visible to and used by immigration authorities. Even a single DUI, which in the past might not have been a priority, is now often enough to trigger a full review of your case. Let me paint a picture of how this could devastate a family. Let's talk about Maria. She's been a lawful permanent resident for 25 years. She came to the U.S. as a young woman, raised her children here, owns her home, and is a beloved member of her community. 2 weeks ago, she was pulled over for a broken taillight. When the officer ran her name, the system didn't just show her perfect driving record. It flagged a misdemeanor shoplifting charge from 30 years ago. She paid a small fine and had completely forgotten about it. In the past, this might not have even been a blip on the radar, but with today's data sharing, that 30-year-old flag could trigger an alert to the local ICE field office. An officer reviewing these newly surfaced records might see the shoplifting offense. While it might not be a deportable offense on its own, it can be considered a crime involving moral turpitude, or CIMT. This could give them the opening they need to start an investigation. Last week, Maria, the 25-year permanent resident, could receive a notice to appear, ordering her to immigration court to face deportation proceedings. The broken taillight could lead to a fight for her life in America. So, what's happening here from a legal perspective? The law that outlines deportability is Section 237 of the Immigration and Nationality Act. This law lists categories of convictions that can lead to removal, with the most dangerous being aggravated felonies and crimes involving moral turpitude, CIMTs. Aggravated felonies are very serious and almost always result in deportation. CIMTs are a much broader category, covering acts of dishonesty, fraud, or theft. The danger is that under heightened enforcement, even a single old CIMT conviction could be used as the basis to initiate removal proceedings. And once you're in court, the government will scrutinize every single aspect of your life. It's not just about that one old conviction anymore. It's about your entire history. You can't afford to be passive. You must be proactive. Here is your protection plan. First, you need to become your own investigator. You can't wait for a traffic stop to learn what's in your file. You must request your own criminal and immigration records. This is a two-step process. Step 1 is to get an FBI identity history summary check. Step 2 is to request your criminal record from the state police or court system in every state you've ever lived in. You need to know exactly what is on your record, including arrests that didn't lead to a conviction, and even expunged records, because ICE might see them anyway. Second, once you have your records, don't try to interpret them yourself. You must schedule a consultation with an experienced immigration attorney. An attorney can analyze your record through the specific lens of immigration law. A crime that a criminal lawyer told you was no big deal could be a very big deal for your green card. They can tell you if any of your past offenses could be classified as a CIMT or an aggravated felony. Third, if you do have a potentially problematic conviction, your attorney may be able to pursue post-conviction relief. This is a complex process where your attorney goes back to the original criminal court to try and vacate or modify the old conviction to eliminate the negative immigration consequences. This has become one of the most powerful tools to protect long-term residents. The bottom line is this: your past is no longer in the past. New data sharing systems have given the government a digital time machine. Don't wait to find out what it might find. Take control of your own history and neutralize risks before they can be used against you. Extended travel, the 180-day red flag. The second trigger putting green card holders at risk involves a dramatic shift in how the government views travel outside the United States. Many permanent residents believe that as long as they return within a year, their status is safe. This is a dangerous misconception and is no longer a safe assumption. Here is the new reality. Under a climate of heightened enforcement, any absence from the United States of more than 180 consecutive days will likely flag your file for enhanced screening upon your return. Before, the burden was clearly on the government to prove you had abandoned your residency. Now, a lengthy trip creates a strong appearance of abandonment, and in practice, the burden of proof is shifting to you to prove that you did not intend to make your home somewhere else. Let's take a real example. David has had a green card for 15 years and works in the US. But because his elderly mother lives overseas, he spends about 7 months each year abroad while still working remotely. He keeps an apartment in the US and pays US taxes. In February, when David returned to JFK Airport after being outside the country for more than 180 days, CBP officers sent him to secondary inspection. This time, the questioning was much stricter. Officers asked for his tax returns and noticed he had used a tax rule that could make it look like his main residence was outside the US. They also asked if he owned a home in America, and David said he only rented. Because of the long trip, the tax paperwork, and weak ties like no property ownership, the officer suspected David may have abandoned his US residency. The officer could not cancel his green card immediately, but he could take it and send David to immigration court. David was shocked. He thought caring for his mother would never put his status at risk. Let's break down the legal concept. A green card gives you lawful permanent residence. The key word is residence. Immigration law requires that you intend to make the United States your permanent home. Abandonment is about your intent, but a long absence is seen as powerful evidence of that intent. CBP officers are trained to look for specific ties to the U.S., like a home, family, job, filing U.S. taxes as a resident, U.S. bank accounts, and a U.S. driver's license. So, how do you protect yourself? You must be meticulous. Here is your protection plan for travel. First, the rule is no longer just don't stay out for 1 year. In 2026, staying outside the US for more than 180 days, 6 months, can create problems. If you plan to be abroad longer, apply for a re-entry permit, Form I-131, before leaving. This document shows you are not giving up your green card and can allow travel for up to 2 years. Second, keep strong ties to the United States. Try not to sell your home or cancel your lease. Keep your U.S. bank accounts active and always file your taxes as a U.S. resident, not a non-resident unless a lawyer advises you. Third, travel with proof that your life is in the U.S. Carry copies of your lease, bank statements, driver's license, and recent tax return. If border officers question you, these documents can help protect your status. The key point is simple. Long trips abroad come with risk. The 180-day clock matters. So stay prepared and avoid giving immigration officers any reason to doubt that the U.S. is your permanent home. We're halfway through and I want to pause. If any of this, old criminal records, new travel rules, is raising concerns, that's a good thing. It means you understand the stakes and need to be proactive. Waiting for a notice in the mail is too late. The time to act is now. Every person's situation is unique. That's why below this video, you'll find a link to schedule a confidential consultation with my legal team. We can help you analyze your specific situation and create a personalized protection plan. Don't leave your future to chance. Now, let's get to the third trigger, which is trapping families who believe they are following the rules. The public charge rule, a new interpretation. The third trigger is the public charge rule. This isn't a new concept. It's been part of U.S. immigration law for a century. Historically, it was mainly used to deny new green card applications. What has changed with shifting enforcement priorities is the risk that past use of benefits could be used against lawful permanent residents in new ways. Here's the problem. The government can look back at your entire history as a green card holder. While using benefits you're entitled to does not automatically make you deportable, it can be used to deny a future application like citizenship. A finding that you were a public charge can then flag your file for further review by DHS. The public charge test itself does not apply when you renew a green card or apply for citizenship. However, it does apply if a green card holder leaves the U.S. for more than 180 days. Let me give you a real-world example. Let's talk about the Chen family. Mr. Chen is a green card holder. 2 years ago, he was laid off from his construction job for 8 months. To feed his U.S. citizen children, he received state-funded food assistance and temporary cash aid. As soon as he found a new job, he stopped using the benefits. Last month, Mr. Chen applied for U.S. citizenship, but during his background check, USCIS questioned his past use of cash assistance and food aid. The officer denied his application, saying it could suggest future dependence on government support. Now, the family fears this record could bring more immigration scrutiny. To stay safe, it's important to understand what public charge means. It refers to someone mainly dependent on the government for basic living. The biggest concerns are cash benefits like SSI or TANF, and long-term government-funded care, such as a nursing home paid by Medicaid. Many other benefits are usually considered safer, including unemployment, emergency Medicaid, WIC, and benefits used by U.S. citizen children. USCIS uses a totality of the circumstances test, meaning they look at your full situation, your age, health, income, education, and financial support. Past use of certain benefits can be a serious negative factor. To protect yourself, know which benefits are risky, speak with an immigration lawyer before applying for aid, and collect proof of self-sufficiency like job records, tax returns, and pay stubs. Also, keep a copy of your affidavit of support, Form I-864, since a strong sponsor can help your case. Simple mistakes and administrative violations. The fourth trigger is maybe the most insidious because it involves actions that seem harmless. We're talking about simple paperwork mistakes. In the past, these were often overlooked. But under a climate of heightened enforcement, Agencies can connect these dots to argue that a green card holder shows a pattern of noncompliance. Here's the problem. A single mistake is a mistake, but two or three unrelated mistakes can now be bundled together, giving the government a reason to scrutinize your entire file. Let's look at Samuel's case. He's a green card holder. Last year, he moved and forgot to file Form AR-11, the change of address form required within 10 days. A few months later, he accidentally checked the U.S. citizen box on an online form for a private club. Then he received a jury duty summons, and knowing he couldn't serve, just threw it away. Separately, these seem minor, but when Samuel applied to renew his green card, the officer, looking for a pattern, saw a different story: failure to report his address, a false claim to citizenship, and failure to comply with a court summons. His renewal is now on hold, and he's been called for an interview. Three tiny mistakes are now being viewed as a single damning character flaw. To protect yourself, you need to treat these small rules with the seriousness the government now does. Let's break these down. First, the change of address form, AR-11. The law requires non-citizens to notify USCIS of a move within 10 days. Failure to do so is a misdemeanor and can even be a ground of deportation, though this was rarely enforced in the past. Now it's being used as a piece of a non-compliance case. Second, a false claim to U.S. citizenship. This is the cardinal sin of immigration law. Knowingly claiming to be a U.S. citizen for any benefit is an almost permanent bar to any immigration status. What's new is that officers are digging into non-governmental records and using even accidental claims as evidence of bad character. Third, jury duty and voting. If you get a jury summons, you can't ignore it. You must fill it out, indicate you are not a citizen, and mail it back. And it should go without saying, you absolutely cannot register to vote or vote in any federal or state election. This is a deportable offense. So how do you bulletproof yourself? Develop a mindset of absolute precision. Here's your plan. Step 1. Do this today. If you have moved and aren't sure you filed an AR-11, go to the USCIS website and file one right now. It is better to file late than never. Step 2. Be obsessive with every form you fill out. When you see the question about citizenship status, go on high alert. Never, ever, ever check the U.S. citizen box. Step 3. Treat any official-looking mail seriously. If you get a jury summons, respond immediately. If you get a notice you don't understand, don't ignore it. Take it to a lawyer. The era of the forgivable mistake is closing. Your job is to be so perfectly compliant that you give them absolutely no ammunition. Trigger number 5, fraud and misrepresentation, the lie that never dies. The fifth and final trigger reaches back to the very beginning of your immigration journey: fraud or material misrepresentation. The rule you must understand is this: there is no statute of limitations for revoking a green card based on fraud. A lie told on a visa application 20 years ago can be uncovered today and used to revoke your green card and deport you. The problem now is that the government's ability to find these old lies has become exponentially more powerful. DHS and USCIS are using sophisticated data analytics that cross-reference every piece of information you've ever submitted: visa applications, green card forms, and even the applications of your family members, to search for a single inconsistency. Let's talk about Isabella's nightmare. She got her green card 15 years ago through marriage. They are still happily married with 2 kids. But on her original visa application, she was asked to list all her siblings. At the time, her brother was undocumented in the U.S. Isabella was scared and left his name off the form. For 15 years, this was her secret. Last month, she applied for U.S. citizenship. This is where new technology came in. The government system cross-referenced her application with her brother's recent application for a work permit, where he listed Isabella as his sister. The system flagged the discrepancy. This was flagged as material misrepresentation. Last week, instead of a citizenship interview, Isabella received a notice of intent to revoke her permanent resident status. The government's argument is that her green card was obtained through fraud. That one decision she made out of fear is now threatening to unravel her entire life. Material misrepresentation is a false statement about a fact that likely would have caused an officer to deny the application if they had known the truth. The devastating part is that it doesn't matter if you would have been approved anyway. The act of lying itself is the basis for the fraud charge. This is the ultimate trap. The immigration system has a perfect memory, and now it has the tools to access it. So how can you protect yourself from a mistake made a decade ago? First, from this moment forward, commit to 100% absolute truth on every single immigration form. The risk of a lie being discovered is higher than ever. It is always better to disclose a complicated truth with the help of an attorney than to tell a lie that could destroy your life a decade from now. Second, if you know there is a misrepresentation in your immigration history, do not file any new applications, not for citizenship, not for a green card renewal, without first consulting an experienced immigration attorney. Filing a new application is like knocking on the government's door and asking them to audit you. An attorney can help you assess the materiality of the lie and advise if a waiver might be available. In some cases, the safest legal advice is to not apply for citizenship. It may be better to remain a lawful permanent resident for life than to apply for citizenship and risk a review that leads to deportation. Your immigration file is a permanent digital record that can be scanned in seconds. Before you volunteer for that audit, know exactly what's in your file. We've covered a lot of heavy information today. The digital ghosts of old criminal records, the 180-day travel red flag, the retroactive use of the public charge rule, the bundling of simple mistakes, and the AI-powered search for old misrepresentations. The message is clear. The rules of the game are changing. Holding a green card is no longer a passive status. It's an active one. Your American dream isn't a trophy on a shelf. It's a living thing that must be protected. But I want you to leave this video with focus, not fear. This knowledge is your power. You now know the tripwires. You have the checklist for each one. Don't let fear paralyze you. Let it motivate you to be prepared, organized, and proactive. And you don't have to do this alone. Your situation is unique. You shouldn't rely on general advice from a video, even this one, for decisions that will affect the rest of your life. That's why my office, the American Dream Legal Center, offers comprehensive case evaluations. We will dive into your immigration history, analyze your record for red flags under these new enforcement priorities, and give you a clear, personalized roadmap to secure your future. Don't wait for a letter from USCIS or a knock on the door from ICE. Take the most important step to protect yourself right now. Click the link in the description below to schedule your consultation today. It is the single most important investment you can make in your peace of mind. If you found this information valuable, please do two simple things. Click the like button so I know this content is helpful, and subscribe to this channel. My team and I are constantly monitoring these policy changes and are committed to bringing you updates. And finally, please share this video with every green card holder you know. You could be giving them the one piece of information that saves them from a devastating mistake. Thank you for watching. Stay informed, stay safe, and protect your American dream.